Hi, everyone. Harry here to talk about Judge Cannon's order denying Trump's motion to dismiss the case based on the Presidential Records Act. Okay, so first and foremost, it is obvious, and she, in fact, basically acknowledges this is the fruits of Jack Smith's filing that said, rule already. You have suggested first, you've given us this bizarro order that asks us just to engage with academic questions of the Presidential Records Act. But there's a couple problems here. The Presidential Records Act has nothing to do with any legal defense, even though Trump keeps saying it. And there's no facts at all to support his claim that he, magically waved his wand, or didn't even wave his wand, imagined inside his mind waving his wand, and all these records became personal. And by the way, that's the exact antithesis of what the Presidential Records Act was passed to do. And by the way, even if he had somehow done it, it wouldn't help because he's charged with possessing certain national defense information, even if that information had been transmogrified into his personal docs. It's still national defense information. It's a really, really garbage theory from top to bottom, but one that he keeps applying. And Jack Smith made the aggressive move on Monday of saying, you got to rule on this. And to the extent you suggested, Judge Cannon, that you might actually go his way at trial when it's too late to retry a defendant under the Constitution. I think most people know this at this point. You're in the dock, a jury is impaneled, and evidence starts. If the jury holds against you, there are a few exceptions to this, but basically you cannot be retried if you're acquitted. Okay, she does a ruling and she denies his motion to dismiss. And that is clearly prompted by Jack Smith. Now, in a way, he might have been spoiling either for her to grant it, because that would have been a really, juicy issue to take up on appeal, because it would have been so flagrantly wrong, and it would have given them a chance to couple the appeal with a motion to recuse her. Or maybe even not to rule, because that's what he had said in his papers. You got to start ruling here, Judge, or we are going to bring a special writ of mandamus, which is just a sort of all-purpose, Court of Appeals, please order the district court to do this or that. We're going to bring that and try to recuse you as well. So she saw that much, and she issued an order. And the order denied his motion to dismiss. All right. There's a little bit of a parting of company in the ranks of commentators and the like. But let me lay this out, because I would say I was on CNN, seconds after it came out, and I said on this, what Smith's saying, 2 cheers for Cannon, which is a way of saying, he's not all that happy, but it's something. I might have said 1 cheer for Cannon, but you are definitely hearing people who want to say 0 cheers for Cannon, or a big old Bronx cheer, raspberry, kill the ump cheer for Cannon. Here's the deal. So she denies the motion. She does it in a little bit by the book. Trump said dismiss, and she said, look, the indictment doesn't talk about the Presidential Records Act. It talks about the Espionage Act. It is adequate on its face. It states a cause of action. It gives you notice, et cetera, et cetera. So you have no basis for saying, because of this extraneous statute, you should dismiss the case. Full stop. Then this nasty paragraph where she first, as is her wont, takes a little bit of a swipe at Jack Smith, saying, to the extent you're suggesting, Jack Smith, that I'm foreclosed from this ruling, from, making decisions about jury instructions at trial, including ones that might have the effect of, I shouldn't put that way, but this is what Jack Smith is saying, it might have the practical effect of kind of forcing an acquittal. I'm not taking that off the table. I could still do that at trial, and it's unjust was a funny word she used for this, to try to tell me otherwise. Okay. To the once burned or 50 times burned, 51st times shy crowd about Judge Cannon. And, I've come around to really have zero confidence in her. They read this as not providing much at all, because she announces she can still screw the U.S. in just this way. I called it the judicial equivalent of a perfect crime. You grant a bogus legal basis, serve in front of the jury, basically direct them to acquit Trump, and bim bam, nothing to be hermetically sealed because it can't go up on appeal because there's double jeopardy. So that's what everyone's worried about, including Jack Smith. And he said, you've got to rule way in advance, so that we have a chance to take an appeal if you do anything funky, rather than we need a chance well before jeopardy attaches. So first, her ruling just says, the face of the indictment is solid, and Presidential Records Act doesn't change anything about that. That's a narrow way of doing it. But this was Trump's motion. It was Trump's motion to dismiss, and she's denying it. I think what Jack Smith is really saying is he ought to be bringing, and perhaps they will forthwith, a motion to say, hold, please, Judge, in advance of trial, that the Presidential Records Act has nothing to do with this case, shouldn't be mentioned, shouldn't be a basis, et cetera, et cetera. Serves up that question. And then, the judge, at least if she takes Jack Smith's instructions hard, she rules on that, hopefully without spending 2 months doing it. And that would be the ruling that he's sort of seeking, saying not simply, okay, the indictment's all right, but actually saying the Presidential Record Act argument is all wet. I think it's quite arguable that Trump's motion to dismiss doesn't serve up the issue as the Presidential Records Act argument, all wet anywhere and everywhere in the case. Now, what about this final little nastygram saying, of course I could, I'm not saying I won't change my mind or do different jury instructions. So there's a neener quality to it, and a justifiably unnerving reaction that it would prompt Jack Smith. And that's the focus that many of my colleagues are putting on and taking to the airwaves, and say she's done nothing and you have to mandamus her now, etc. To my mind, that's overwrought. However, a judge can always pull some crap with ridiculous jury instructions that are in the heat of trial. I've actually had it happen once and knew it was going to happen. And there's a way, it's almost like a sporting event, but where you immediately move for a mistrial as the prosecution and immediately file an appeal in the Court of Appeals, divesting the court of jurisdiction. So you keep the judge from granting an order that then would stop the music because of double jeopardy. But in any event, in what she said, it's got a little bit of cheek to it. It's got a little bit of pushback, and I'm in charge here, Jack Smith, even though you gave me a pretty damn firm motion. And I don't see the big heartburn there, because it's something that's just always present. So she reminds people that it's present, and she, basically shows I'm not being taken to heel yet. Okay, but that went without saying. So thus my assessment of 2 cheers, 1 cheer for Judge Cannon, or for the situation, and others' assessment of 0 cheer. But there's now whispers, among commentators. So take her up now. But on what? She's made a solid ruling against Trump on the, indictment-centered theory of Presidential Records Act. She hasn't really needed to do something broader. So first you'd have to put that in front of her. And the mere statement that maybe down the line she would consider jury instructions that would have the effect of tubing the whole trial, that's not a ruling. You can't do a mandamus saying, make her foreclose all stupid jury instructions now. So to my mind, first of all, it's impressive and important that Jack Smith comes in with this forceful motion and stops screwing around, and she does. She does it in a way that's, definitely a little bit hedging, a little bit sort of keeping her pride, pushing back, etc., and carries the seeds of possible mischief down the line. But those seeds are, were in the ground already. So thus my 1.5 to 2 cheers for Judge Cannon, and my modest disagreement with some of my colleagues whose views you should fully consider, as hopefully you consider mine. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.